सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Good morning, respected speaker of today's session, Advocate Pradeep Joy, sir, and my fellow committee members and my dear professional colleagues. A very good morning to all of you. Today, the topic before us for discussion is Insolvency and Bankruptcy Code, a new dimension for CA. The Insolvency and Bankruptcy Code was passed by the Parliament is a welcome overall of the existing framework dealing with insolvency of corporates, individuals, partnerships, and other entities. It paves the way for much needed reforms while focusing on creditor-driven insolvency resolution. The code offers a uniform, comprehensive insolvency legislation encompassing all companies, partnerships, and individuals. One of the fundamental features of the code is that it allows a creditor to assess the viability of a debtor as a business decision and agree upon a plan for its revival or a speedy liquidation. The code creates a new institutional framework consisting of a regulator, insolvency professionals, information utilities, and adjudicating mechanisms that will facilitate a formal and time-bound insolvency resolution process and liquidation. We have with us an eminent faculty, Advocate Pradeep Joy from Cochin, who will elaborate us about the code and the professional opportunities for CAs. Thank you, sir, for accepting our invitation to be the faculty. Hearty welcome to you, Pradeep, sir, for this program.
Thank you, sir. Thank you.
I welcome each and every participants of this program. Thank you. Now over to Cherianji, our Vice Chairman, for the formal introduction of our faculty, Pradeep Joy, sir. Over to Cherianji.
Thank you, sir. Very good morning to everyone. Today we have with us an eminent speaker, Advocate Pradeep Joy, dealing with the subject Insolvency and Bankruptcy Code. Advocate Pradeep owns a corporate full service law firm at Ernakulam under the banner PJ Law Offices. The firm focuses on fintech and technology communication, structuring and negotiating legal terms for commercial transactions, insolvency and debt restructuring, intellectual property rights and employment, legal support for special situations, and disputes resolution. He has got over 16 years of experience in the legal industry. His law firm experience includes working with India Law and SNG and partners at Mumbai, dealing with banking and finance practice. His in-house experience involved working with Spur Bank of Russia at Delhi, Indian School Finance Company at Hyderabad, Grey Matters Capital, a venture capital fund based in Atlanta, USA. With this brief introduction, we welcome you to the webinar. Over to you, sir.
Thank you, sir. Yeah, very good morning to all. Thank you, Ramesh sir, for this warm introduction. Thank you, Rima, the secretary of the chapter, for being present. Thank you, Mr. Cherian, for the initial introduction which you have given. Thank you so much for this opportunity to be before this particular chapter. And it's always a pleasure to speak on the subject matter when we have worked on it for a very long period. And this is the 4th year of the code. And I would say I'm a 4-year-old insolvency and bankruptcy lawyer. So it has been something new to me, something not conventional from what I've been practicing earlier. But for last 4 years, I've been focusing on this particular vertical day in and day out. Fortunately, been part of approximately 600 specific insolvency cases across India, and has been a very interesting journey during the past 4 years by being part of various committee of creditors, various part of various advocacy forums. So things has been really happening on the space, and I would say with the 4 years focus given, I have no regrets on that, and things has been really good. And the most satisfying of all from an insolvency and bankruptcy practice point of view is many of the distressed businesses which were lying very low, we could see that coming back again to a functional mechanism. And many of the debts which were due to the banks, and because of which the banking system was totally in a peril, we could see those getting restarted. So when we saw that, it's really a very interesting journey compared to what I've been practicing earlier in the debt recovery tribunal, or from a SURFACE Act point of view, where we were looking only at the recovery of the debts. And therefore, when we saw the revival, I felt this is very interesting, and this gives a new energy for various businesses which had left the scope of being revived or contributing back to the economy. Let me, before going through the presentation which I have, let me just briefly mention the various stakeholders and how we can be really helpful to various stakeholders when an insolvency resolution happens. One of the primary stakeholder in an insolvency matter is the business itself, and the business needs various supports, and the business needs a holistic support which requires a professional, a chartered accountant who can understand the business very well. Second, there are various creditors, which includes the financial creditors, the operational creditors. Then there are the promoters who are there, who are also in a way creditor to the company, because they are the shareholders and they come under the category other creditors. Then there is government, where because the various government dues which is on to the government. And then there are certain requirements which are needed for an insolvency or a resolution process to continue, which include conducting a valuation for the business itself. And during the CIRP, there is also a need for a forensic study of what has happened in the company and what led to the distress in the business. And again, when we go, we see adjudicatory forums, which is NCLT, NCLAT, and the Supreme Court, which has been playing very active role during past 4 years. The role of the regulator, needless to say, we have to give a word of appreciation for the regulator who is very active in this particular domain, which is the Insolvency and Bankruptcy Board of India, which has become one of the most credible regulators in the world. Especially, even a very brief lookout on their website, it gives us a complete understanding of how the court performs, and the data which is there, which include the various newsletters, the various research reports, the various studies which has been happening during past 4 years or even before that. That's duly compiled, duly cross-referenced, and everything is available in the IBBA website. There is also a new vertical which has come up, which is the information utility services. We earlier could see in the debt reporting mechanism, we had always seen the CIBIL or the credit information companies playing a very key role. We have also seen under the SURFACE Act, the CERSAI, where the security interest is being reported. They also has become another repository mechanism. In addition to that, under the code, now we have information utility, where all or any kind of defaults or payment mechanisms can be reported. And in addition to that, it brings out a particular fact. If there is a report in the information utility, then it becomes an admitted liability. So all what is being led as part of the Insolvency and Bankruptcy Code is the development of a new financial culture, a culture which needs more discipline, a culture which needs more transparency, and also a culture which which takes us away from the conventional form of litigation which we are seeing in the courts, where there is no end or there is no timeline which is being complied with, and because of that the creditors are at loss, the business is at loss, and nothing happens. So totally it was a stalemate kind of a situation. But now we are seeing a situation where there is a scope or a potential for a revival, and also we see some kind of a solution happening. Whether it is pleasing to all the stakeholders or not, that's a different question altogether. But at least we see certain aspects, certain elements coming positive, and there are certain elements which are negative. There is also one more stakeholder which is being of key aspect in this particular process. They are the personal guarantors too, personal guarantors of a corporate debtor. Now this is also a new dimension. We have rarely come across bankruptcy regime for individuals in India, although we had certain legislations. But now this is going to have a new implication where we are going to see how a bankruptcy regime will work against individuals in India. With this, let me place my presentation also on the screen. Can I do that?
Yes.
Yes, sir. Yes.
During the course of the presentation, if there is any questions, please feel free to ask it. In fact, we are 4-year-old in the regime, and most of the chartered accountants would have probably already been privy to many of the corporate insolvency resolution process, and it would be a great pleasure to share and hear their experience, as well as whatever questions they have, so that we can do the presentation in a very interactive way. So please feel free anytime to ask questions. The initial part of the presentation, it focuses on what we had previously in India and what we were following, and these are very essential to understand, because it gives us a clear understanding on what we had and what we do not have in the absence of a bankruptcy regime in India. So the pretext, we should look for 3 periods. One is the pre-independence period, although it's not much relevant today. The second is the post-independence period till the reforms period. And post the reforms period, what has happened? So in the pre-independence period, we had the civil litigation forums, which we were relying for debt recovery. And still we continue to have that. Absolutely, there is no replacement of the civil courts or the jurisdiction of a civil forum. Only, if you look at, there are only certain additions which has happened from a legislative or from a debt recovery standpoint. The civil courts are still there. The civil courts function on a 2-tiered mechanism. One, first the adjudication happens, and as we all know, we have a adversarial system where we rely on proofs, and the proofs lead to a judgment, and then the judgment has to be executed in an execution court. So multiple layers of getting the result. In the average period, when we look pre-independence, probably it would have been very, very easy to get a judgment or to execute a decree, provided it was in it is in a location where it could be executed at that point in time. But but at least the time span which we could see, at least certain data, what it shows, at least in a year or 2 or 3, there would have been some solutions. But going forward, and when we look to the present days, if we go to civil court, it takes an average of approximately 8 to 10 years to reach to any kind of logical conclusion if the litigating parties are lucky enough to have such kind of a conclusion. The second is the various insolvency legislations which were there pre-independence, and these legislations also continue even on this date. The one is the Presidency Towns Insolvency Act 1909, and the second law is the Provincial Insolvency Act 1920. And both, in the difference is primarily which locations these legislations are applicable. And one of the primary character of this particular legislation is either the debt has to be an admitted liability for this insolvency proceedings to get initiated, or it has to be duly adjudicated by a court of law, which is same like a civil litigation. First, there has to be a judgment, and then based on the judgment, there could have been an insolvency proceedings. Of late, or in my lifetime as a lawyer, I have not seen these two legislations, although it's still active, and there is a provision in the Insolvency and Bankruptcy Code to repeal it. But even till then, I have never seen both legislations being tested in a court. Probably there has been there may be few lucky lawyers who would have dealt with this particular situation, but I have not dealt with either of them. Post the independence period, first we had the Industrial Development and Regulation Act 1951. Then we had the Companies Act 1956. And third, we had the various, the continuing legislation, the insolvency and insolvency legislations which we had, and the civil law remedies which we discussed just before. And the Companies Act had a very detailed mechanism of how the companies could be wound up and how the creditors could be paid. And the Companies Act 1956 had very detailed provisions. There too, one of the primary challenge was how to get the process concluded either before the High Court or in the subsequent forums, or in a situation where liability is disputed. And if a liability is disputed, the Companies Act could never turn to be a plausible legislation for any kind of remedy. In all these legislations, the shortcomings were there was lack of time frame, did not prescribe a cost mechanism on how these things could complete, lack of competency in the people who are handling it, the liquidators, or even the courts, or even lawyers, or any persons who are dealing with that. We had our own limitations for the respective stakeholders, because to understand all kind of businesses by everyone, or including the courts, if they need to understand every kind of business situation, that is extremely difficult. And because of that difficulty itself, there was lack of competency, and the lack of competency led to unviable situation. And we could see many of the factories or factory land just lying free without anything happening there for a very long period. And there was absolutely no institutional support, which we can see today in the way how IBBI gives a support, or in the way how government gives support, or how the legislative gives support, or how the Supreme Court or the other courts give support for bringing in IBC active. The institutional support we could never see earlier, but that all led to the proceedings being functioning without any respect for the timeline, and speed was not an essence at that point in time. Later on, post the fourth and the fifth 5-year plan, the SIC Industrial Companies Act 1985 came, and the intention was to be a preventive legislation, and it had a preference for restructuring. But of late, SICA also lacked institutional support. And it was extremely, the authorities got clogged with lots of matters, and a revival or a CDR mechanism or a revival mechanism which SICA could offer, it consumed not less than 5 years on an average from a data standpoint for any company to even have a resolution plan. Same problems. This was the shortcomings. No institutional support, no defined timeline, and the misuse was more than the positive aspects. And this under SICA, the debtors were always in control of the company. So the company was with the promoters always during the SICA regime, and SICA is now repealed. And post the reform period, that is after 1993, and when we had the liberalization, we had various committees which came, and also, primarily due to the balance of payment crisis, we needed more effective regime. And Narasimhan Committee report, which came in 1991, recommended for broad-based financial sector reforms. And as a result of which, we saw various legislations which came up after that. One is definitely the DRT Act. The second one is the SARFAESI Act. And third one is the most used debt recovery regime in India, the amendment to the Negotiable Instruments Act, and whereby check bounce cases were made criminal. And these were the post-reform period. And none of these legislations, although SARFAESI had the intent of becoming, at least, there was a mention about a revival or a takeover of management of a borrower. Finally, it led to a situation where only this is a legislation. Finally, it led to a situation where it caters only to the requirement of secured financial creditors and not to anyone. And that led to two categories of reforms, one by Government of India and one by the Reserve Bank. And the Government of India, as I already mentioned, it was a legislative effort. Firstly, the Recovery of Debts Due to Banks and Financial Institutions Act 1993. It led to the DRT, establishment of DRT. Initially, the processes were very clear, but of late, what has happened, the DRT has clogged with cases. And yeah, I'm seeing DRTs functional in Kerala and in few other states, but I have not seen DRT functioning in cities like Mumbai, especially because of the fact that the number of cases there in DRTs are very substantial. And if you file a case, we do not even know, if a financial creditor files a case, we do not even know when the case is going to be taken up, at least at stage where there can be a notice issued to the borrower. And needless to say, when the recovery can happen. And this led to a situation where, the rating of India from a contract enforcement standpoint went to a rock bottom. It led to a situation where there is a common saying, if we say we'll see in court, then it means nothing happens. So the respect for the entire judicial system or the entire law enforcement system from a civil law enforcement point of view, that got totally deteriorated. Although the legislative reforms were with the intent to create more reforms, but because of the lack of management of how the systems and the processes were, it led to a situation where nothing is happening. Securitization, we already mentioned briefly about it. We saw the establishment of asset reconstruction companies, which is capable for taking over the bad debts from various banks and financial institutions. And we also saw Companies Act 2013 again, which came out again with the detailed procedure for winding up, liquidation, and also establishing the adjudicatory forums like Company Law Tribunal and National Company Law Tribunal. And Securitization Act, which came in 2002, that's very important. It helped to fast-pace enforcement of security interest in a faster pace. But it didn't have an adjudicatory mechanism. It was totally a recovery law, the part in the Securitization Act which had where there is a requirement for takeover of management of a company that is not yet notified till date. And Securitization Act eventually it lost its clamor because of the multiple litigations which came up in various courts, and also due to various multiple judgments of various high courts which came, and it led to a situation where again the law which was supposed to be implemented within defined time frame could never be implemented as it was thought for. And ARCs, asset reconstruction companies, lacked capital. The market which was supposed to cater, which is the bad debt, distressed debt market, which ARCs could have catered, it didn't flourish much because of lack of adequate capital or further enforcement of contracts by ARCs. So post that, as a part of not as a part of the legislative reforms, but as a part of supervisory reforms by Reserve Bank of India, we could see RBI coming up with mechanisms where RBI came out and had a policy regarding corporate debt restructuring scheme. There is a policy. The RBI also came up with a policy regarding flexible structuring of existing long-term projects, which is also called the 5:25 scheme. Then we saw another scheme coming up, which is called the strategic debt restructuring scheme. And then finally, RBI came up with the S4S scheme, which is also known as the scheme for sustainable structuring of stressed asset. And these all happened during the regime of Honorable Governor Mr. Raghuram Rajan. And we also saw RBI coming up with a platform for the lenders in the country to report large default, which is also called CRILIC, the CRILIC reporting structure, and also the reporting for SMA1, SMA2, which is required for various financial institutions to now have an early reporting of credit defaults that came up. And these were the reforms which were led by RBI, and none of these reforms are there today. These all are overridden by the Insolvency and Bankruptcy Code. 2014, with the new government in place, the Bankruptcy Law Reforms Committee came into action. As a backdrop, when we look, the NCLTs came up in the 2013 Act, and there was a very detailed study of how NCLT should function, and that was based on the IRADI committee report of how adjudicatory mechanisms can be developed in India outside as a tribunal, and how it can be made more effective. So 2013, we had the Companies Act, we had the IRADI committee report, and by 2004, and then the NCLTs and the NCLATs were set up. And the appellate jurisdiction of NCLT and NCLAT is the Honorable Supreme Court. So a three-tiered mechanism. One is the original forum, the second one is the appellate forum, and the third one is Supreme Court. And these are very essential to be considered. These are forums where chartered accountants, company secretaries, ICWAs, and lawyers can practice without any distinction. And this is slightly different from procedures in NCLT or in the appellate jurisdictions are different from what we see in a conventional civil court. There it is here, the most important factor is it's a departure from the conventional civil litigation. It is not an adversarial system, which means there is no requirement for cross-examination, or there is no requirement for of what we see in a court, a regular court. What NCLTs and NCLATs need to do is they need to follow the principles of natural justice, and they can only rely upon documents which can be proved on a prima facie perusal. Something which is not reliable, they cannot consider. It's not a court per se, where where the evidentiary process, the Evidence Act does not have much role in the adjudication mechanism. And the Bankruptcy Law Reform Committee came in 2014. It was headed by Mr. T.K. Vishwanath. And prior to that, if you look again as a pretext, if you look, the reform started from 1964, the 24th Law Commission report regarding the provincial insolvency, and then the Tiwari Committee report came up in 1981 for SICA. Then the Narasimhan Committee report, based on which the Debt Recovery Act was framed in 1993. Then the Narasimhan Committee report 2, it came in 2002. That was for the SARFAESI Act. Then we had the Aradi Committee report. As I said, the Aradi Committee, after Mr. Justice Aradi passed away, the NCLT came up, but the report was even launched. The first report even came in 2002, and it even proposed a repeal of SICA. And then we had the Ellen Mitra Committee, which proposed a comprehensive bankruptcy code that was as early as in 2001. Then we had the 2005 Irani Committee report, which spoke about the enforcement of security interest and the debt recovery bill, with amendments to the SARFAESI Act as well as the DRT Act. In 2008, as a part of the Planning Commission, Mr. Raghuram Rajan also proposed improvements to the credit infrastructure, and we saw certain results of that. The policies which we mentioned earlier, the CRILIC reporting platform which came earlier, and all those led to certain reforms. It led to some productive effort, but not something as we could see as the bankruptcy regime. In 2013, the draft Indian Financial Code, which include a resolution for corporations, again, this was also led by the Finance Ministry. It proposed a financial sector legislative reforms. This particular reforms have not been yet put into place, but when we look into the bankruptcy reforms, what has been happening from 1964, this chart gives a brief understanding of what have been happening over a period of time. BLRC, it came in 2014 under the chairmanship of T.K. Vishwanath. It filed 2 reports, and it proposed the bankruptcy code to be in place. And one of the most interesting proposition which came as part of the BLRC report was, conventionally we had government dues ranking in priority when it comes to sale of security or sale of an asset of a borrower. And what the government did, what the BLRC did as an initial proposal was a suggestion to the government to deprioritize the government dues. And second was to promote revival of the corporate debtor, and for that to bring in a mechanism which facilitate a speedy disposal. This is the base history of how the Bankruptcy Law Reforms Committee functioned. In 2014, the committee was formed. In 2015, the draft bill was submitted. In 2015, the bill was introduced in the Lok Sabha, and in 2016, it was passed by the Lok Sabha. And in 2016 May, the President's Accord, we received it, and in December 2016, the Act was fully launched, and thereafter we saw the various actions before various forums. These are the objectives of the Act. It consolidates the laws relating to reorganization of businesses, and it provides for a framework for insolvency resolution of corporate persons, partnership firms, individuals in a time-bound manner. And the main object of the Act is to promote entrepreneurship, availability of credit, balance interest of all stakeholders. And one of the most important aspect of this law is to lower the priority of government dues and to establish IBBI. So when we compare the object of the SARFAESI Act, the object was to provide an effective mechanism for enforcement of security interest. But when it comes to the object of Insolvency and Bankruptcy Code, the objective is much broader. It is a legislation in national interest. It also deprioritizes the government dues so that there can be more availability of credit or the secured creditors. As a matter of fact, they get more priority, and thereby there will be a lot of importance. There is more confidence for a secured creditor to lend money to the market, and thereby it promotes entrepreneurship. And also it is proposed to do all these activities in a way it balance the interest of all stakeholders, which includes the shareholders, the promoters, the operational creditors, the financial creditors, and others who are involved in a resolution plan. Broadly, it's applicable for almost all kind of persons which we can see, legal persons, which include companies, limited liability partnerships, body corporates, personal guarantors, partnership firms, and individuals. Now, when we say this, as of today, the law is notified only for companies, limited liability partnerships, and personal guarantors to corporate debtors. It is not made applicable for partnership firms or proprietorship firms or for individuals. And we, after the legislation, we saw the government doing a very phased rollout of the code, because this is a law which is totally a departure from what has been happening earlier. And we have never come across a law where the debtor, where the creditors came in control, as Ramesh sir was saying in the beginning. This is a law which led the creditors to be in control of the company. And previously we saw the legislations where the debtors were always continued to be in control of the business. And right with the bankruptcy code, the creditors came in, and there was a resolution professional who was supposed to be in control of the company post that. So this is totally a departure from what we could see from the previous regime and the Insolvency and Bankruptcy Code. So the government very wisely, what they did, they phased out the various activities under the code. Initially, the notification only permitted proceedings against companies and limited liability partnerships. And in November 2019, finally, the government gave the nod for proceedings against personal guarantors of the corporate debtors. So a very wise phased rollout of the plan. So approximately, it took the law as it stands today. We saw 9 notifications based on which the government commenced various provisions of the code. So an immediate notification of the entire provisions of the code would have been a disaster, because of the system and the scheme in which we function, and the way in which courts will appreciate arguments by various stakeholders at different levels, rightly anticipating that to get the law matured, and because of the fact that it's going to change the financial culture of the country, the government faced the rollout, and through 9 notifications, the various provisions came into being. And there was not 9, 11 notifications, and there was 9 times the law was amended to meet the requirements and then to cure the gap. Never in our fiscal legislative history we have seen the government giving such an importance for improving a legislation. 9 times in a short span of time, starting from 2016 to 2021, the law got amended. 11 times various notifications came. And in addition to that, if you look into the history in the subordinate legislations, which means the rules made by IBBI, we could see innumerable times IBBI coming up with a lot of clarifications which helps the legislation to function. And that was very important, because we were conventionally used to disputing the situation, what we typically do in a civil court: evidence, cross-examination, and finally lead to a judgment, and from there to an execution process. that was totally replaced. The adversarial system was totally replaced. The prominence is only for natural justice. Because, I mean, even as a lawyer, I don't really understand, if there is a loan document which is executed by a borrower, or what is the requirement for the same to be again adjudicated in a court of law to give a judgment, especially by, if the particular, if the loan is given by a bank, because the Bankers Book Evidence Act again reaffirms the sanctity of the account statements given by the banks as well. So, being a total departure from what we were seeing it, the government made the applicability and the notifications in a timely manner and in a phased manner. The next is the framework. Under what framework the insolvency regime functions. We have insolvency resolution professional, which came in as a regulated class of persons who will lead the insolvency resolution process. So once a company is admitted under a corporate insolvency resolution process, the management of the company, the directors of the company is suspended, and the management of the company is with a resolution professional. And all decisions which happens in the company, it happens either at the level of the resolution professional, or it happens at the level of the committee of creditors. So the resolution professional plus the committee of creditors, they will control the business of the company for the period in which the corporate insolvency resolution process will happen. Second is, we saw the setup of information utility, and this is an agency to collect, collate, authenticate, and disseminate financial information. And right now we have NESL, which is one of the information utility which is being set up, and it provides opportunity for all businesses to report payments which is to be received by them. And once, both the payer as well as the payee, or somebody who is required to pay or somebody who is required to receive the money, once they have reported this in the information, the relevant contract in the information utility, then it is deemed to be an admitted liability, which is also something which is new in our norms. The next is, we saw the setup of National Company Law Tribunal, and we saw the setup of we also saw National Company Law Appellate Tribunal getting very active in insolvency matters. And in the framework of the legislation, we have Debt Recovery Tribunal, which is another body where where personal insolvency will be tested. We also saw IBBI, which has become one of the most credible regulator. So this is the broad framework. Next is the salient features of the code. The salient features deals with again, it's an institutional framework. Pre-IBC regime, we had multiple legislations, multiple forums. IBC regime, we are limited to a single forum, and the approach is generally ex post, and in IBC it is mostly ex ante. Objective is recovery in the previous regime, and IBC we have revival and continuation. IBC processes can be initiated by a stakeholder who is a creditor to a corporate debtor, RBI or government. The relevance of RBI and government comes in situations where there is a financial institution or something similar to a financial institution. Let's say if an NBFC is requiring a resolution, we saw it in the Diwan Housing Finance matter, where RBI is initiating a process for corporate insolvency resolution process under the IBC code. And we also saw the government initiating a CIRP process in the Island Affairs matter, although not under the code, but under the Companies Act. We saw even after the IBC code, we saw the government initiating an action, because that time the notification based on IBC regime was not in place. In the previous legislation, the debtors are in possession, and in the IBC regime, the creditor is in control. From a professionalism standpoint, no regulated service or regulator was there in the previous regime. And now we have insolvency professionals, insolvency professional agencies, insolvency utilities, regulator is IBBI. Once a CIRP process is admitted against a corporate debtor, there was nothing which provided for a moratorium except in SICA. And SICA was a very difficult forum to get any results in a short span of time. Under the IBC process, we have a moratorium immediately after a particular case is admitted before NCLT. And once a particular CIRP process is initiated, immediately an interim resolution professional takes over, and the interim resolution professional will be in charge and control of the company. And within 30 days, a committee of creditors has to be constituted. For that, the insolvency resolution professional, immediately upon his appointment, has to invite claims. And once the claims are invited, whether it is disputed, legal, or undisputed claims, the insolvency resolution professional has to verify and admit the claim, and post that, the financial creditors will become part of the committee, and the rest, operational creditors, will not be part of the committee. In the previous regime, the priority in case of a liquidation waterfall, the government stood on the top of the list. And in the present regime, the government stands at the bottom of the list, only above the equity holder. In the previous regime, we had an official liquidator appointed by the High Court in case of a liquidation. In the present regime, an insolvency professional, who is either the resolution professional during the CIRP or somebody who is newly appointed, will act as the liquidator. And for cross-border enforcement actions, it was governed by the Code of Civil Procedure Code and the common law principles. And the cross-border enforcement under the Insolvency and Bankruptcy Code. Right now, we are not a signatory to the UN Citral Law on cross-border insolvency. Our country, India, is not a signatory to that. Once India becomes a signatory, which we hope shortly would happen, once the government has a priority for that post the COVID period, we will see cross-border insolvency actions against errant promoters who are residing outside India after huge debt defaults in India. And we also recently saw in one of the recent cases, Supreme Court suggesting cross-border enforcement actions under the Insolvency Code against people and properties outside India. Sir, any questions? Anyone?
Sir, we can go at the end of session, we can take, sir.
Sure, yeah. So in the insolvency regime, there are two categories of debts. One is financial debt, and the most important factor for a financial debt is the debt should have a time value for money. So the contract which reflects or records the financial debt, it should have a time value for money. And financial debt, or the most important thing is, it's not given by a financial institution. It can be given by anyone. Any one of us can be a financial creditor to a corporate debtor, because especially if there is a time value for money. So time value for money, I would say it can be either in the form of interest, it can be in the form of redemption value in case of a bonds. So in both the cases, if the character of the debt is linked with time value for money, we become the debt become a financial debt, and the person who has given the financial debt, he becomes a financial creditor. And a financial creditor will have a seat in the committee of creditors, and he will have a voting share depending on what is the verified claim. And operational debt can be any debt which is based on supply of goods or services to the corporate debtor. And there are two categories of operational debt which we typically see. One is the operational debt of the employees and the operational debt of other categories. One is the government or the persons who have supplied goods or services. There is difference in how the entitlement or the distribution would be once there is a liquidation or there is a resolution plan. The employees will always continue to be on the top compared to other operational creditors. Although the definition of the debt may be same, but from an entitlement point of view or from a ranking point of view, during a resolution or a liquidation, employees have a different stature. Who can file an application for CIRP? CIRP can be initiated by a financial creditor, operational creditor, or a corporate debtor. Who cannot initiate a CIRP process? The CIRP cannot be initiated by a corporate debtor undergoing a corporate insolvency resolution process, or a pre-packed insolvency resolution process, or a financial creditor undergoing pre-packed insolvency resolution process. So anyone who is presently undergoing CIRP or PIRP cannot initiate, or anyone who has any corporate debtor who has completed CIRP in the preceding 12 months, they also cannot. And even if there is a resolution plan which is approved, a particular corporate debtor cannot initiate a insolvency resolution process. Any corporate debtor or financial creditor who has violated the terms of the resolution plan in the preceding 12 months, they also cannot initiate a corporate insolvency resolution process. And the last one, any corporate debtor against whom the liquidation order has been passed, they also cannot initiate a CIRP process. The features of CIRP, it enables resolution at the earliest. It's a time-bound process. The BLRC report clearly specifies the concept of speed is of essence in a insolvency resolution matter. And the reason which they have cited is, with each continuing day of default, the scope for revival and the value of the asset of the corporate debtor, it diminishes, or the value of the business diminish, and it provides for a time-bound manner. The code was very clear on it. Once an application is filed, the admission of the matter had to be given in 14 days. Then there is a model timeline given in the insolvency regulation on within how many days what has to happen. But unfortunately, what happened, the timelines got relaxed by the Honorable Supreme Court in one of the matters. So nowadays we see, earlier, at least in the beginning, we could see insolvency resolutions applications getting admitted by NCLT within 14 days. Now we don't see that admissions getting admitted in 14 days. In 2016, when the court came, at least the first 300 matters, we saw insolvency resolutions getting admitted within 14 days. And post that, it lost the time value from an admission standpoint. But even then, when we look at the overall timeline, it has reduced to, on an average, the insolvency resolution or the liquidation happens within a period of 333 days. It also envisages the resolution of the corporate debtor on a going concern basis, and it provides for, it provides an opportunity for viable and feasible resolutions to happen. It also distinguishes what a judicial aspect, from a judicial aspect, what has to be considered, or from a commercial angle, what has to be considered. There is a clear segregation of commercial and judicial aspects of a resolution process, and it provides for balancing interest of all stakeholders. So this is how a very broad flowchart of how a CARP process can happen. The application will be to the adjudicating authority. This can be an application under Section 7, which is an application which can be initiated by a financial creditor, or it can be an application under Section 9, an application to be initiated by a operational creditor. And there is slight difference in process when an operational creditor initiates a process compared to how a financial creditor can initiate a process. The operational creditor will need to give a notice, a 10 days notice with a demand. And the second aspect is an operational creditor will not be allowed to initiate a corporate insolvency resolution process if the liability is disputed. So if there is a pre-existing dispute, then a corporate debtor proceedings by an operational creditor will not be possible. But for a financial creditor, even if there is a pre-dispute, it's not a concern. They can still initiate and the application will get admitted. And the third aspect is the corporate debtor themselves, subject to a special resolution passed by its shareholders, can initiate a CARP process against themselves. So 3 modes of application under Section 7, Section 9, and Section 10. And the result can be, 1, the application may get rejected if it does not satisfy the necessary requirement, or the application gets accepted. Once the application is accepted, the characters are the corporate debtor will be under moratorium. Once there is a moratorium, there cannot be any initiation of suit or any proceedings against a corporate debtor. There will be an appointment of an interim resolution professional, and the CARP will commence on the date notified by the NCLT. And once RP is appointed, once the insolvency resolution professional is appointed, it will lead to public announcements, and the public announcement will be for collection and verification of claims. And here, the word claim is important. The claim can be anything which is a right to payment. It is duly defined in the code. It can be a disputed liability, an undisputed liability, a legal claim, or whatever heads we call. If there is adequate documentation supporting the claim, anyone can file a claim in a defined format given under the CIRP regulations. So once the claim is given, the RP, the insolvency resolution professional, is required to verify the claim. And the verification will not be an adjudicatory kind of verification. If the claim is given and if there is sufficient proof, and the proofs include contracts, financial statement, bank statements, or documents or contracts supporting the claim. And if those documents are available, then the RP, without any adjudication, is required to admit the claim. And from the various claimants, whoever has given a financial debt, they will be permitted to form a committee of creditors. We call it COC. And once the COC is up in place, the COC appoints a interim resolution professional to a resolution professional. The COC may also change the resolution professional in some cases, depending on their discretion. And once a resolution professional is appointed, then there are very detailed protocol which he need to follow, which is first to start with the process for inviting expression of interest from persons who are interested in taking over the corporate debtor and its business. And from among the expression of interest which a resolution professional received, the resolution professional, in consultation with the committee of creditors, will funnel them into eligible resolution applicants who can submit a resolution application. And the criteria for refining the processes, who can submit the expression of interest, who can be an eligible resolution applicant, and what should be there in the process, these are decided by the committee of creditors. And the Honorable Supreme Court has already mentioned it all those aspects are not, all those aspects are commercial wisdom of the committee. So the committee can define the processes, the committee can define the eligibility criteria of various parties who may be resolution applicants, and thereafter the committee of creditors can analyze the resolution plan after the RP examining the plan and then certifying that the plan is in line with the provisions of the code. And the committee can either reject the plan or the committee may approve the plan. And if there is a vote, once the RP put the plan for vote, and if there is 66%, then the plan will be binding on all the stakeholders, which include the members of the company, which is the shareholders, the creditors of the company, the government, the central government, and the state government, and all persons who are involved in the resolution process. And once the committee approves it, it doesn't, the final approval of the plan is not there. It goes to the NCLT, and the NCLT has to give its approval under section 31. And if the plan is not approved, then the COC, or the NCLT has to pass a liquidation order. Once the liquidation order is passed, that's a separate protocol which is to be followed, which means the liquidator will be appointed. The liquidator has to do the steps, which I'll be explaining it in the next slides. But if the plan is approved, then it is implementation of the plan, and the entire control of the corporate debtor, irrespective of what the promoters think, it goes to the resolution applicant. These are the functions of the interim resolution professional, primarily to manage operations, assets, and finances of the CD, gather all claims, form the committee of creditors, manage finance, and all other duties as directed by the Insolvency and Bankruptcy Board of India. And one of the primary requirements which an insolvency resolution professional has to cater is to maintain the company as a going concern. And the word going concern has a lot of meaning in a CARP process. And the entire spirit of the legislation is to maintain the corporate debtor as a going concern. We already spoke about moratorium. Once the corporate insolvency resolution process is admitted, there are certain restrictions. There cannot be any institution or continuation of suits or proceedings against the corporate debtor, which means, let's say if there is a SARFAESI proceedings, let's say if there is a DRT proceedings, if there is any proceedings before any civil court or any forums, including, let's say even if there is an income tax assessment happening against a corporate debtor, all those has to be restricted. Everything stalls there. There cannot be any transferring or encumbering assets of CD. There can be a limited transfer beyond the moratorium, that is up to 10% of the total asset. That is for financing for the CD during the corporate insolvency resolution process. That's an exemption to this. There cannot be any action to recover, foreclose or enforce security interest. Again, it's continuation to the first part. There cannot be any SARFAESI proceedings or DRT proceedings. Let's say the property wherein any property in the possession of the CD also cannot be taken back. If there is a leasehold property with the corporate debtor, then the lease will continue. Committee of creditors, broadly, they are the decision-making body in CARP for all commercial decision. It will be comprised of financial creditors of the CD. And voting share will be proportionate to the financial debt owed to such financial creditors. These are the duties of the resolution professional. They will manage and control the corporate debtor. They will verify the claim, raise interim finance if required, prepare information memorandum, invite and examine resolution plans. And they also defend the corporate debtor before various forums. This is the process regarding invitation of resolution plan. So there are broadly 4 aspects when it comes to resolution plan. And prior to the resolution plan, we have the process of inviting the expression of interest. Then comes the submission of the plan. Then comes the approval of the resolution plan by COC. No, it's, yeah, sorry, I jumped on the buttons. Sorry. Yeah, first is inviting of the expression of interest. Once the expression of interest is called, there will be a publication of provisional list of eligible prospective resolution applicants. Then if there is any objections or exclusions, that has to be considered by the resolution professional and the committee of creditors. Then comes the final list of prospective resolution applicants. There will be, post the issue of final prospective resolution applicant, there will be issuance of memorandum and request for resolution plan. And based on that, there will be a submission of resolution plan to the resolution professional. Post that, approval of resolution plan by the committee of creditors, which means there need to be 66% of vote. And thereafter, there will be submission of approved resolution plan to adjudicating authority. And finally, the adjudicating authority approves the resolution plan. So, the most important process in this, it starts with the submission of resolution plan. So under section 30 of the Insolvency and Bankruptcy Code, a resolution under section 30 subclause 1, a resolution applicant submits the resolution plan to the resolution professional. And post that, under section 30 subclause 2, the resolution professional examine the plan. And post that, under section 30 subclause 6, a committee of creditors, after taking into consideration the priority and the security interest as provided under section 53. Section 53 provides a distribution waterfall. So the committee of creditors, after taking into consideration the priority and distribution as provided under section 53 of the code, they have to give a vote. And also the committee of creditors has to ascertain the feasibility and viability of the plan. Once the committee of creditors vote the plan, the process at the COC level is over. Then the RP has to submit the resolution plan, and the NCLT has to pass an order under section 31 of the code. Thereafter, if the plan is not approved either by the committee of creditors or by the NCLT, then it is led to liquidation under section 30 subclause 6 of the code. These are the basic characters which are required to be there in a resolution plan. It should provide the term of the plan and how it is going to be implemented, how the management and control of the business of the CD has to be mentioned. It should also have an adequate means for supervising its implementation. The cause of the default has to be duly mentioned. How the plan is going to be feasible and viable has to be very clearly mentioned. It has to have a definite provisions for effective implementation. It has to provide certain timelines. And RA's capability to implement the plan should also be clearly mentioned. We already mentioned about how what are the adjudicating authorities. There are two adjudicating forums. One is the National Company Law Tribunal for corporate persons, and the second is the Debt Recovery Tribunal for individuals and partnership. The Debt Recovery Tribunal part is not yet notified. Right now, we have only National Company Law Tribunal for corporate persons and for personal guarantors. So if there is any proceedings which is to be initiated against a personal guarantor of a corporate debtor, that will still continue to be before the National Company Law Tribunal, where a proceeding is initiated against a corporate person. And the powers of the NCLT are very broad. NCLT, we have to note that NCLT is an adjudicatory forum. NCLT is not a civil court. It's a forum where there are two officers, one with the capability, one with the technical capability, and one who is an expert on the judicial side. And they can decide any application against a corporate debtor or a corporate person. It can decide on matters related to claim made against the subsidiaries or against a corporate person. It can also settle question of priorities of any question of law or facts. Or it can also give directions to various persons to cooperate to a CIRP process. And these are the broad powers of the NCLT, and they can also approve the resolution plan And the NCLT has the power to entertain any kind of appeal which go against an order of the NCLT, and from there it goes to the Supreme Court. And one of the most important factor which we needs to which we can factor in before the NCLT, things are more faster than civil court. It was faster earlier before the COVID period. The COVID has affected the speed a little, but even then, NCLT seems to be a very apt forum for deciding commercial aspects as well as the to address the requirements for a commercial resolution compared to what we can see in other judicial forums. The next is the process of liquidation. Liquidation is a process where we are not able to find a successful resolution plan. Then the only option is to lead the company to liquidation. Even in liquidation, the object of the code provides for liquidation as a going concern. We have come across at least 5 or 6 liquidation as a going concern, which happened initially with the Topworth case, which is a case based in Nagpur. That was the first case where the liquidation was permitted on a going concern basis. Otherwise, liquidation also permits piecemeal sale of assets of the corporate debtor in the way it is beneficial for the creditors. And the liquidation process will be initiated on certain grounds. The committee of creditors, right at the inception of the process, if they feel there is no scope for resolution plan, they can immediately vote for liquidation, and that's one ground. Second is the committee of creditors, if they are not able to finalize upon a resolution plan before expiry of the CIRP period, and the CIRP period is typically a period of 180 days in the beginning to start with, it may get extended up to 270 days, or to a maximum, it may go up to 333 days. That's what is prescribed under section 13 of the code. So at section 12 of the code. So if the CIRP does not complete within that period, or if there is no exclusion period granted by the NCLT, then the only option for an adjudicating authority, which is NCLT, is to permit liquidation of the corporate debtor. And if the corporate debtor has to be liquidated, then there will be a liquidator in place. There is a difference in role between a resolution professional and a liquidator. Liquidator has adjudicatory authorities, and a resolution professional does not have any adjudicatory powers with him. Typically, RP is appointed as a liquidator, and the liquidator forms estate of the assets. They collect the claims of the creditors within 30 days, and then they verify or reject the claim, and post that they sell the asset and then distribute the assets. And the broad timeline which is prescribed for liquidation is a period of 1 year. So as envisaged in the code, if the timelines rightly function, a matter has to be admitted in 14 days by the NCLT. And the process of CIRP, with whatever extended period, it has to get concluded within 333 days. And if that is not successful, the process has to get over within 1 more year, which is with the liquidation. And after 1 year, the company has to be led to a dissolution. So this is what the timelines are reflecting as on today. The role of the liquidator, we already mentioned about it. It's much similar to that of a resolution professional. Collect, verify, and consolidate claims. Take into custody and control of all assets of the corporate debtor. Sell immobile and mobile and actionable claims. Settle claims of creditors and distribute proceeds in accordance with the waterfall mechanism under the code. And the waterfall mechanism under the code provides at level 1, the insolvency resolution process cost or the liquidation cost. Second level, it comes to employees workmen due for 24 months, and then the dues to the secured creditors on a pari passu basis. Then comes to the employee's claim. Then comes the unsecured financial creditor. And post that it comes government dues, operational creditors and government dues on a pari passu basis. Then comes the dues to the equity shareholders. There was a difference. Yeah, I'll get to that distribution waterfall later. But right now the role of liquidator is to distribute the distribution as per the waterfall defined under section 53 of the code. Insolvency and Bankruptcy Board, effective regulator, one of the most credible regulator in India right now. It was established in 2016. It regulates both professionals and the transactions involved. And we see often IBBI taking up various initiatives. One is the advocacy initiative, one is the training initiative, and also they play a key role in spreading and disseminating informations with respect to insolvency, and to also discipline the professionals involved whenever it is very, very required. It is composed of a chairperson, and there are 3 members from among the office of the central government, one to represent the Ministry of Finance, Corporate Affairs and Law, and they are ex officio members. And there is 1 member nominated by RBI, who is again an ex officio member. And there are 5 members nominated by the central government, and at least 3 of them are full-time members. Its functions are quasi-legislative, executive, and quasi-judicial. The quasi-judicial function comes because of their supervisory jurisdiction on the insolvency resolution professionals, and the executive powers comes mostly because of how they are enforcing various activities as a part of functions of the board. And the quasi-legislative acts, they are eligible, they are empowered under the code to come up with various subordinate norms based on which how the code has to function. This is the history of amendments under the code, and the various key factors which happened over a period of time. The first amendment came in wherein section 29 capital A was inserted, and 29 capital A provides for certain ineligibility of parties to become resolution applicants. This was inserted with the objective to ensure that any person who is not duly eligible from an ethical or a moral standpoint, which is, and again, that is clearly mentioned there, one who is, let's say a person is a willful defaulter or convicted of an offense where there is a moral turpitude, or let's say person is already not paying a debt, and that has exceeded a period prior to 1 year, or if person is not eligible to be part of a securities sale in architecture in India, if he's barred by SEBI, then they cannot become part of, they cannot again come and then acquire as a resolution applicant. Fundamentally, this was this particular clause was inserted to prevent promoters who are not eligible to again come back and then get the company and get over the debt without enforcing their obligations. Yeah. So initially, when we had the code, there was no clarity where real estate projects, where the allottees of a real estate project, whether they were financial creditors or operational creditors. Subsequently, we had a lot of Supreme Court judgments which clarified that allottees of real estate projects, they are operational creditors. And finally, that got incorporated into the Act. And now the allottees as defined under RERA will also be financial creditors, and they will have a seat in the COC. Technically speaking, they will become unsecured financial creditors. Third, during the second amendment, we saw the COC's decision, the normal decision threshold came down to 51%, and of the COC members present, and also for key decisions, it was 66% of the total COC members. And also we saw in certain cases at a particular stage, 12 12A of the code, 12 capital A of the code was inserted, wherein there was a possible option for withdrawal of CIRP applications. And this required 90% of vote of the committee of creditors. The next amendment, this is the amendment which came in August 2019. And this was after a lot of study and after a lot of actions which happened in various courts. So when I look at this particular legislation, there is a history to that, because initially, when we look at section 53, there is a mention about how assets of the corporate debtor has to be distributed. That was regarding the liquidation estate of the corporate debtor. And the interpretation which we used to give was that's applicable only in case of a liquidation. And during a CIRP process, we used to fight in the court for an equal treatment between all the creditors, the operational creditors, financial creditors, and employees. We used to seek for equal treatment. And post the SR Steel judgment, which came out in the year 2019 September, it came out in the month of June from the NCLAT. The NCLAT upheld our argument on that, where we asked for almost a kind of pari passu arrangement for all the creditors. But that affected the secured creditors' interest, and the secured creditors went up to Supreme Court. And in addition to that, in August 2019, the Parliament amended the legislation, inserted provisions which include an overall limit of section 330 days for total completion of the resolution process. Second, it permitted class of creditors to vote. The definition of class of creditors got incorporated into the code. And third, the eligibility, what is eligible for an operational creditor, that got clearly incorporated into the code. And it is clearly mentioned now in the code that it is an amount, it's receivable under liquidation, or an amount receivable under a resolution plan. So whenever class action has to be initiated, it came out with the requirement for 100 creditors or 100% of the total creditors. This is not applicable in a normal case. It is applicable in the case of real estate allottees, where they need to have 100 creditors or 10%. And in addition, section 32A came in, and this also was after a lot of deliberations in the Parliament. There will, after this, there will not be even a criminal liability on the corporate debtor, which was an ambiguous thing prior to insertion of section 32A. So post-COVID, there has been a lot of changes which happened, and continuation of the code would have been a difficult aspect. And on March 25, there was a prohibition installed for initiation of CIRP process, and it got extended to 1 year. And post 1 year, now again the code is implementable. And there will be a lot of actions which we will be seeing in the near future. Yeah. So, and post, the 2021 amendment came up with one of the most interesting factor into the code, which it permits medium and small scale enterprises, which is very important for our economy, to come up with pre-packaged insolvency resolution process. So this was not usual. This is to provide for a faster resolution mechanism in case of small and medium scale enterprises. With the latest definition, the small and medium enterprises definition will be applicable in many of the companies which we generally see around. So this particular opportunity will provide an effective mechanism where there is a seal of a code for a restructuring process, and in the absence of in the event of non-compliance, there will be an effective redressal mechanism under the code. That's one of the key aspects which we need to remember when it comes to prepackaged insolvency resolution process, which is also called PIRP. This is the prepackaged resolution process. It can start whenever there is a minimum default of 10 lakh and there should not be any proceedings against the corporate debtor at that point in time. There should not be an existing CIRP proceedings, and if there is no existing CIRP proceedings, then the corporate debtor themselves can start a PIRP process. And the applicability, it's applicable for micro, small and medium enterprises. A CD who has defaulted amounts to rupees 10 lakhs, subject to not completed a CIRP or undergone PIRP in the past 3 years, not undergone a CIRP process, no liquidation order has been passed in respect of the debt, eligible under section 29A to submit a resolution plan. Proposed RP has to be approved, resolution plan has to be approved by the financial creditors. Declaration by majority of directors, partners of the CD. Special resolution of shareholders, partners approving the initiation of PIRP. The CD whose financial creditor 66% has to approve again for the PIRP plan. We already mentioned about it. It can be initiated by an MSME. This is the broad process of how a PIRP process will work. Initially, there will be a discussion between the corporate debtor and the creditors. There has to be a proposal and approval of a resolution professional to be appointed. There has to be a declaration by majority of the directors and the partners. And post that, there has to be a special resolution by the members or the resolution of the partners. Then there can be a FC approval for filing. Then the application can be filed. Adjudicating authority has to pass an order of admission. Then it comes to a public announcement. After the public announcement, for submission of claims, various claims will be received. And at this point in time, a base plan has to be submitted by the corporate debtor and a preliminary information memorandum has to be prepared. This has to be prepared. The base plan has to be submitted to the resolution professional, and the preliminary information memorandum has to be submitted to, prepared by the RP and submitted to the committee of creditors. Committee of creditors has to appoint valuer. All these things happen together: appointment of committee of creditors, submission of base plan, and first meeting of the committee. All these things will happen at the same time. And after that, the COC approves or rejects the base plan. And if the COC approves the base plan, RP to submit the approved plan to adjudicating authority, and adjudicating approves the plan. And if the plan is not, then it becomes binding on all the stakeholders. And if the adjudicating authority rejects, the plan will be, again, the process will need to restart. And if also there can be an option for alternate plan to be submitted to the COC. If the COC rejects the plan, that's another step thereafter which needs to start. It starts with invitation to potential RAs for alternate plans. Receipt of alternate resolution plans has to come from third parties. If alternate plans is not significantly better, then base plan and alternate plans to complete. Adjudicating authority, then it goes to a two-step process. There can be a situation where there is no plan approved by COC, then it leads to a liquidation. If there is a plan approved, then the plan approval, plan to be filed with adjudicating authority for approval, and adjudicating authority approves, or adjudicating authority rejects and pass liquidation order. So finally, it ends either with the resolution plan or with the liquidation order, and this is expected to complete within a period of 90 days. This is the prepackaged insolvency resolution process is in line with Government of India's vision for support to medium and small scale enterprises for an effective restructuring of their debt, especially considering the present crisis because of the COVID situations. Yeah. And in 2019 August, something another aspect which got initiated was the process, the resolution process against personal guarantors, and the government notified the provisions regarding insolvency resolution against individual and made those applicable exclusively for personal guarantor of the corporate debtor. Under section 60 of the code, the jurisdiction is with NCLT. The process starts with an application filed either by the personal guarantor or a creditor. With the filing of application, an interim moratorium commences. There will be a resolution professional who is going to be appointed, and the resolution professional examines the application and submits a report with recommendation. Adjudicating authority pass an order either admitting or rejecting the application. So the process starts based on section 2E, which defines personal guarantor of the corporate debtor, and the jurisdiction is with NCLT. So it is under section 60 subclause 1 and 2. And the invoking provision is under section 94 and 95. And 94 is the provision based on which a personal guarantor can self-initiate an action, or 95 is a provision based on which a creditor can initiate an action against a personal guarantor. And unlike a corporate debtor, if the personal guarantor is not able to reach to an insolvency resolution situation by submitting a repayment plan, then the steps will be different. The steps will lead the personal guarantors to face a bankruptcy proceedings. There will be a bankruptcy trustee appointed. The bankruptcy trustee will take control of assets of the personal guarantor, and then they will liquidate the asset which has value. There are certain thresholds of value, and there are certain restricted assets. Other than that, everything can be liquidated by the bankruptcy trustee. And once the bankruptcy trustee performs that, and after completion of a period of 2 years, the concerned personal guarantor or the individual will be free from all the asset, all the debts and liabilities, and he will be permitted to have a fresh start. This we have already mentioned it. This is how a process can continue. The next is professional opportunities under the Insolvency and Bankruptcy Code. For me, it has definitely become an interesting professional opportunity and a positive professional opportunity, because it led to a lot of revival of distressed companies. We could see companies getting revived and opportunities again getting back to track. Many of them who were no solutions cases. There was no, many of the companies, it was in a situation where neither the promoter, neither the lenders, neither the employees, all of them, they were just moving on without any prospect. And at least many of them, they could come back to an actual resolution. That's very important. And right now, when we look at the numbers, as on 31st March 2021, among the various cases, we could see 335 resolution plans which got admitted, which got approved. And one of the most interesting professional opportunity is to become a resolution professional. It can either be by way of passing a limited insolvency examination or by becoming a graduate insolvency program. And graduate insolvency program is a 2-year program, and limited insolvency exam is for those professionals who have at least 10 years of experience, and graduate insolvency program will have to attend the courses physically. And opportunities for professionals, we all can become insolvency resolution professionals. We can participate in preparing pre-CIRP preparations. the business is one of the most important stakeholder in a insolvency process. So one of the most important thing which these days, which comes to me as a lawyer for a work, is to prevent a company from getting on to an insolvency situation. So we plan it, along with the company's financial advisors and other legal advisors, to see what all options can be laid down to prevent a company to be led to IBC. So asset and business planning, whenever there is right decisions to be taken to liquidate an asset and then discharge a company from not dealing with unviable financial situation. That's one of the most interesting aspect in a business, taking the right decision at the right time. And it can happen only with the expertise of financial advisors and lawyers for companies these days, because it's too difficult for a promoter to segregate himself from the business and then take a decision to avoid a distress situation. So, we rightly come in at that space and then help them to cut the losses at the right time and plan for not leading the company to a bankruptcy situation or an insolvency situation. And if, as I said in the beginning, there are various stakeholders. First is the business. Then if the business is not the stakeholder, then we have stakeholders which include the resolution professional, and we can also become the resolution professional. Then thereafter, there are stakeholders which include financial creditors, operational creditors, there are other creditors, and there is a very important role which we can also play to support one of the creditors, who are the resolution applicants, for working out detailed restructuring plan, detailed resolution plans. And these are the things which we can support. And also to specify few of them, what I have mentioned here is assisting IP in preparing, insolvency professional in preparing for pre-CIRP preparations. And this is very important. IPs are being advised, IPs advise financial institutions for pre-CIRP related actions. Then reviewing the various risks involved in the restructuring. This is also very important. Developing risk mitigation strategies. That's another very important aspect. Then working out detailed bankable financial structure for the business. Very important for the business. Right, cash flow is very important, and how to work out bank support. That's very important. Working out a detailed plan for restructuring the business from all angles. Assessment of distressed asset, cash position, due diligence, and turnaround feasibility. Assessing cross-border insolvency transactions, negotiating settlements, advisory in relation to merger or acquisition or takeover, advisory service to management on ongoing basis, bankruptcy of personal guarantors, firms, and individuals. Here too, we have to play a very important role in supporting all these persons and handling the liquidation process, managing the interim finance, and supporting and evaluating distressed companies. So these are almost, every aspects which touch upon various elements of insolvency and various elements of what we see in various processes related to implementation of the code. And something which I heard from IBBI also during one of the conferences is they're coming up with mediation opportunities before insolvency process getting initiated. And that's also one of the very important aspect, right? And nobody likes the company to go away from them. And if there can be a mediated settlement which can happen prior to initiation of the corporate insolvency resolution process, better sense prevail amongst all the parties, and what can rightly come out as a business solution, we don't need to lead it to a court-driven process. And if there can be a process which leads to those kind of settlements with all right spirits and fair interest of all parties, that should be something which needs to be promoted. And that will also turn around to be one of the most interesting professional verticals which insolvency practitioners will be able to support. These are certain figures on what has happened till date. And as on March, the situations on how many matters are admitted, how many matters reach to a closure, and how how it's ongoing. So if you look at the 2021 numbers, and this data is from IBBI and from the latest newsletters, today we see approximately around 4,376 matters, and there is closure for at least 2,653 matters, and ongoing matters we are seeing approximately around 1,723 matters. So at least reaching 2,653 matters to a possible solution, that's a huge number. That's a huge number from a company standpoint, and these numbers are related to corporate debtors. Ideally, this would have gone to approximately 8 years, minimum 8 years. So making this kind of a conclusion in a short span of time, that's very important. Getting to a solution stage, whether it is likable or not, that's a different aspect. But reaching a solution for 2,653 cases through a legally defined architecture, that's a very impressive number. So this is the timelines. In some matters, it has taken at least in 79% of the cases, we see more than 270 days. In some, we have also seen less than 90 days for approximately 12%. While the desire should be for this 12% to increase, so that it gets concluded in the desired timeline. Yeah, less than 90 days, it's a very desirable thing, but I feel, from a general CIRP process standpoint, less than 90 days may be a very utopian thing. Greater than 90 days, and what we see there as 12%, if we are able to increase the numbers there, that's a very important, that'll improve the efficiency of the code as well. This is how there are modes of closure of CIRPs. 48% went to liquidation, 23% is settled at appeal or review. There is 16% which led to settlement under Section 12A, and approval, finally, which led to revival plan is 13%. And when we compare this data, the data has to be compared with what was happening pre-IBC. Pre-IBC, these numbers were absent, and we can say in all these cases, these were zero. And when we look zero as the base, what we see here as the number, that is something which needs to be considered. Zero compared to 13%, that is much better than what we had before 2014. This is timelines for ongoing liquidation. And as we mentioned earlier, we could see 1 year is the optimal timeline, and what is the timeline prescribed under the code. 1 year to 2 years, although 1 year is the timeline, we have seen only very few cases within that. That comes to around 6% of the total number of liquidations. But more than 1 year and 2 years, we are seeing approximately 43%, and more than 2 years, 26%. We cannot blame, these kind of timelines being consumed on any persons, because it takes, to rightly identify the right value of the asset and then to sell it during liquidation. It may take more time than we expect. And also the nuances, COVID would have increased the timeline by at least 30 to 40%. If not, this 43% would have been much lesser. So the reasons for liquidations, in at least 725 matters, we saw the COC decided for liquidation. And in 501 matters, we saw resolution plans not received, which means, there was no takers for the company. In 46 cases, we saw the resolution plan rejected for non-compliances. And one of the most important thing to note here is none of the resolution plans which went up to Supreme Court was rejected. Even if we see 46% here, these were matters disallowed at the NCLAT level. Probably this also include subsequently addressed plans, but from a number standpoint, we are just putting 46% there. But every matter which went to Supreme Court, it finally concluded with the resolution plan approved. None of the resolution plans are set aside. And point number 5, CD contravened the provisions of the code. We could see at least 5 cases. These are the cases which included Amtech Auto is one, Orchid Pharma is another, and there has been few other cases in Kerala. Also, we have one matter where the resolution plan is contravened by the resolution profession, by the resolution applicant. In those matters too, we could subsequently see resolution plans coming, which is in Orchid Pharma. Although there was contravention of resolution plan by the resolution applicant, subsequently we saw the resolution plan being approved with a new resolution applicant coming in. Commencement of voluntary liquidation. This is another chart, but not linked with not linked too much with IBC code. Voluntary liquidation is also under the code, so not very. So voluntary liquidation is typically a situation where the company does not have much to cater to any of its stakeholders. Even there, we are seeing faster conclusion of the process. And if you see in March 2021, the numbers are significant when it comes to commenced and closed. And we are only at the month of June, right? So these numbers will go on higher. Yeah. So the recognitions which we could see, India was said to be a jurisdiction where we had a very low ranking with respect to contract enforcement. Now, at least, we see one of the, we're tagged as one of the most improved jurisdiction for contract and restructuring, the Global Restructuring Review Award for the most improved jurisdiction. And this particular recognition is IBC contributed significantly for our country for this particular award. And the World Bank ease of doing business for the survey improved us to reach 56th place to reach 52 from 108. We reached to 52 among the 190 countries. So earlier, pre 2014, we were even below 108. Which means nothing could happen from a contract law enforcement point of view. And now with this IBC code and its effective implementation, we saw our country ranking, which is very important for investors to trust our judicial and our contract enforcement architecture. This particular standards are very, very essential for investors to trust our country. And this improvement, what has happened from 108 to 56, and then from there to 52. This is a significant improvement. In the 2020 edition of Global Innovation Index, in India's ranking improved to 47 from 95, and this is also a contribution which we are seeing based on the Insolvency and Bankruptcy Code. Thank you. And with this, most of the points which I have concluded it. I'll be open to hear any questions or any suggestions or any queries.
It's done. You can unmute and ask now. The unmute is enabled now. You can unmute and ask any questions, or alternatively, you can put in the chat box. Sir, is there any limit for the number of cases a person can handle? That is resolution cases. A limit of a number of companies, like for any.
Yeah. Thank you, Ramesh, sir. This is regarding the insolvency resolution. How many cases a person can be an insolvency resolution professional, right? Correct, right, sir?
Yes.
That's
so there are, the once NCLT appoints the resolution professional, right, and and for that they take a note from IBBI, and 3 is the maximum number which we can see for a resolution professional to carry on at a single point in time.
Okay. There is no minimum period like the things, no? Minimum and the maximum period within which you have to complete the process, like.
Yeah, so the process, there is nothing called minimum period, but when we look into the process starts with expression of interest. There is a defined timeline for that, which needs to happen immediately after the COC is constituted. So day one, insolvency resolution professional is appointed. Post that, he has to give a notification inviting claims. And within 30 days, the committee of creditors gets constituted. And from there, expression of interest is invited, verified, and finally, so, minimum we will see practically 60 to 70 days. Maximum can go up to 330 days. 330 days, even there, 330 days is like a very tough target. We have seen cases going up to 5 years, which is, SR still went up to 4.5 years, right?
Any questions, members, please?
Sir, can I?
Yes.
Actually, how to become an insolvency professional? That's what.
Yeah, there are two options which you have. One, you can become a graduate insolvency professional. You can join the course. There are various institutes providing that, and it's a 2-year program. Second is you can become a resolution professional by writing the limited insolvency exam. And for that, you need to be a lawyer, a chartered accountant, a company secretary, or ICWA or MBA, and you need to have 10 years of experience.
10 years of experience.
Yeah.
Sir, for that graduate course, what is the basic qualification?
Any degree.
Any degree, okay.
So CA will not be counted there if having only chartered accountants.
I mean, of course, you can have, chartered accountant can also write an exam for a graduate insolvency resolution examination. Even if you are not, if you want to have an early beginning, you can get to the program. If you don't have the sufficient years of experience, then definitely you can write the exam and then become an early professional there. And this is very important profession hereafter, because nowadays I don't see the need for financial institutions to go into any other kind of legislation, especially the secured lenders. As I mentioned during the discussion, the government deprioritized the government dues compared to other, with the secured creditors due. Now, for what reason a secured creditor should go under an IBC, under a SARFAESI process? He will definitely go only under IBC, and therefore IBC is going to most probably replace the entire legislations, because that gives priority for the financial creditors who are secured creditors to get the recovery. And now, when that is the option, why should that not be the primary legislation? And even if you become an insolvency resolution professional at the early stage of the career, and this being what is going to be the market situation in India, and prior to IBC, we were staring at a debt pile of approximately 20 lakh crores as a country. So 20 lakh crores recovery is what is being envisaged. And when the architecture which is required for to reach out to those recovery mechanisms when the need is higher, and it's still growing, the distress pile is still growing, and when adequate professionals are required, even if a 2-year time period for a graduate insolvency studies are spent, that's a very worthwhile exercise for any person.
Thank you, sir. Thank you.
Any questions? Thank you, sir. Thank you, Pradeep Joy, sir, for the excellent presentation and enlightening our members on IBC, a new perspective for CA. We are surely enlightened, sir. Thank you once again for happily accepting our invitation to be the faculty in a short notice. Thank you, sir. Thank you once again. Now I request our Secretary Rama Sharma for the formal vote of thanks.
Thank you, Ramesh, sir. Respected Chairman of Tirunelveli branch of ICA, CA Ramesh Kumar S., my colleagues in the Managing Committee, our learned speaker for the day, Advocate Pradeep Joy, and my dear members who are present for the seminar. A very good afternoon to all of you. To begin with, let me express my deepest gratitude to Advocate Pradeep Joy sir for readily consenting and being here with us and giving us an idea on this novel topic, IBC, and how we as chartered accountants can use this IBC in our professional practice and how we can look forward into this area. Like he said, it is a very novel topic which has only got 4 years of existence. So we all have tremendous opportunities, and he has given an excellent deliberation on how it works and what are the various aspects and procedures involved in it. I'm sure that we all have been benefited a lot, and thank you so much, sir, for enlightening on this topic. And we really appreciate you for your continuous lecture for the past 2 hours without even taking a small break. Thank you so much, sir. Next, I thank all the members of Trivandrum branch for being here with us, for your patient listening. I'm sure that you all have been benefited and are logging out with so much of knowledge in hand now. With this, we can conclude. Uh, all of you stay home, stay safe, and stay virtually connected. Loka Samasta Sugino Bandhu. Jai Hind and Jai ICI. Thank you, sir, once again.
Thank you.
Thank you.
Thank you
Thank
so
you.
much.
Thank you. Thank you.
Thank you, everyone.